Hello and welcome to our show, Dying to Know. My name is George Herodes and I'm with the Mount Elliott Cemetery Association. Most of our viewers know of our Guardian Angel Cemetery just north of Rochester and of course our Resurrection Cemetery in Clinton Township. The goal of our program is to bring you topics and guests that'll help you make life's important decisions that'll help you protect your loved ones. Today I'm excited to bring our guest to you, who is Terry Gempetroni, owner and attorney at Legal Strategies, and we've been very excited to have you on our show. Terry does estate planning,
Yep.
and this is always a very interesting subject for our audience.
Thank
and
you.
We've been anxious to have you on to answer all of our questions. I guess I want to know, certain people are still iffy whether they need it or not. So what
Yeah.
happens to people if they've never made an estate plan?
Well, they're in luck, so to speak, because the state of Michigan has made a plan for them. Now, that might not be the plan they wanted, so that's why it's good to have this conversation with your loved ones, with an attorney. But if you've done absolutely nothing, the state of Michigan assumes that you would like your assets to go to your closest blood relatives.
Okay.
All right, so spouse, if you left a spouse, no spouse, it would go to your children. And in most cases, that probably is what folks want. The problem is it doesn't customize what people have in mind. For instance, if you support a charity during your life and you wanted to leave them some money, well, the state's not going to write in your favorite charity to your estate plan.
I see.
If there's personal items that maybe are very sentimental for certain people, the state's not going to write in who gets your grandmother's china or your grandfather's pocket watch, that type of thing. So if you do nothing, there is a plan, but in many cases it's not the plan that you would have created if you had sat down and spent the time.
I see. Are there ways to do a do-it-yourself? I always hear about those do-it-yourself estate plan kits.
You know, there's old TV episodes where people are, stranded on an island and they have to write it in the sand, that type of thing. The law actually does allow a handwritten will. So if you were in a situation where there was no other option, you could write the will and sign it. Interestingly, there was a recent case from Ohio where someone wrote it on his iPad.
No kidding.
He was in the hospital, the prognosis came back and it was grim, and he didn't want to leave anything to chance, so he wrote it on his iPad. The question became whether he had signed it or not, because electronic signature isn't possible. So the case did find that it was a valid will. It went to court, unfortunately, for the family, but it was upheld as a will. So you can do it yourself. The risk is you might forget something that a professional would jog your memory about, like personal items. Has there been loans to people that will now be deducted from their inheritance? Are certain people maybe unable to manage their money, and you want to set up some parameters for when and how they get their inheritance? Things like that are a little more sophisticated than just everything goes to my wife. That may be why you'd want to work this out with a trained attorney.
Is that one of the drawbacks then of do it yourself?
Yeah,
Okay.
is that you'll forget something.
I remember when we did ours, they make you think of things that you normally don't think of.
Exactly.
And there was a lot of awkward pauses where, okay, what do I really want? Or
Right.
who? Or
Well, that's why at our office, if you call, we send you a questionnaire before you come in for your first appointment. So
Start
you get a
thinking.
preview of some of those tough questions. You can have conversations with people that you may be appointing in your documents. Especially I see this where couples have to name a guardian for minor children.
yeah. So
That's
important.
a very difficult decision, and they don't want to think about that for the first time in my conference room. They want to have had that conversation at home, talk to some of the family members that are likely candidates to ask if they would do that. So that preview time is very important because, like you said, you get a lot of really mind-bending questions when you start your estate
Sure.
plan.
Oh yeah, it's exhausting.
It is.
I
It can
remember.
be exhausting.
Yeah.
Yeah.
So it's best to hire someone like you rather than go to Staples and maybe buy forms to
kit.
fill out, or what they have, DVDs or CDs.
They have
you can-
CDs, I understand. There's a couple risks with that, and I've not read every possible form that you can go online and get or buy it at Office Max or Susie Orman's kit or that. There's a couple risks, though. One is what state's laws are going to apply in those documents. Were they drafted in New York? Were they drafted in California? Are those laws somehow different than what happens in Michigan? So that's the first question. Then the second question is just, do they go through the litany of things that you might want to think about? You know, you may not be thinking about your pets, but to some people, those are like family members. Who will get their pets if they're not here to finish caring for them, for example? So things like that, I don't know that those forms are as exhaustive as they need to be to ask you all those what-if questions.
Now, I hear it. One of the most important things to learn out of something like this is to avoid probate court. Isn't that true?
No. Probate does get a black eye and get blamed for a lot of ills, some of which I think have nothing to do with probate. So we spend a lot of time dispelling the urban legends of probate.
People get scared of that.
Well, and to be honest, some people have marketed the fear of probate so that you come in and buy their service or their product. So to be telling you that probate's the boogeyman may be good for their business.
I see.
But here's some of the common myths I hear. I heard these just yesterday, as a matter of fact. Probate's going to take half my money, and then the rest will go to my children. That's absolutely not true. Probate does not get a commission from your assets for you using the probate court.
Okay.
There will be a fee of $150 to open a probate estate. And then depending on what's on the inventory, the list of assets going through probate, there will be a fee. That fee will be less than 1%. Not 25, not 50, less than 1%.
See the fear?
See the fear, of course. You work hard. You fear that your children aren't going to get their true inheritance because the probate court will take all this money off the top. Not true. The other thing I hear all the time is how long probate takes. I've had families tell me, we went through probate, it took 3 years, it took 4 years. My hunch is either there was a family fight going on that took 3 or 4 years to resolve, or there was some asset that needed a lot of time, like a business that you can't just sell off. You need to be very methodical about it, or someone in the family wants to buy it and it takes a while for them to raise the money. But probate itself does not take 3 or 4 years. In fact, after a year, probate court is sending out a notice saying, tick-tock, either wrap it up or tell us why you need more time. So they don't want files to get old and moldy at the probate court either. They want them to be wrapped up and closed in the court.
So they're a little more helpful than what we are led to believe.
Exactly.
Yeah.
Exactly.
Now, what does probate have to do? Does it affect inheritance and maybe inheritance tax? How does all that?
That's a great question, because a lot of people confuse the cost of probate court with inheritance tax. Inheritance tax is from the IRS. Okay, national. It has nothing to do with whether you go to Macomb probate when someone dies. So recently, the laws were changed so that each of us taxpayers can pass $5.2 million worth of assets at our death. So for most of my clients, estate taxes are a thing of the past. They don't have more than $5 million, and for a couple, over $10.5 million. I
see.
Before they would have to worry about an estate tax affecting their family. Yeah, so that is not really the scary thing that it was not even that many years ago before the tax laws got reformed.
So you're clearing up a lot of the myths about going to probate court. Are there any other misconceptions people have that you...
They think if you go to probate, then your will is out the window and the family decides what happens. A lot of folks equate a probate court proceeding with a will challenge, which is not the case. No. There's very narrow ways you can challenge a will. One is to show that the person was absolutely not competent and that when he or she signed the document, they didn't understand what it was. To do that, you pretty much need medical evidence to show that someone was, an Alzheimer's victim or was on some kind of pain meds that were so strong they couldn't understand what they were signing. The other way to show it is what's called undue influence. If someone has such control over a vulnerable person that they made them sign a document against their will, then you could throw that document out. But again, that's a very difficult thing to prove.
So just because my estate goes to probate doesn't mean my will is thrown out the window?
No, just the opposite. It's probate's job to give that will effect and make it valid and make sure that the person you named in the will is the one appointed to handle things and that the things that are done according to that will.
Okay.
Yep.
Well, I guess now that leads me into my next question is, what's a living trust and what does that do?
Well, for people who do want to avoid probate, trust is a good way to do that.
Okay.
A trust is just a private way to transition your assets. As opposed to a court that appoints the person you named in your will, you lay out in a trust who's in charge in the event of your disability or death and what do you want them to do. So trusts are used very commonly when we have small children who we don't want to inherit money until they're more mature. You can set up a variety of ways for them to get money or a variety of ages at which they get their inheritance. If there's a blended family, his kids, her kids, you often see people setting up a trust to be sure that both sets of children are protected and that one spouse can't disinherit their stepkids.
Yeah,
that type of thing. For people who have a business and they need that to be continued and run by someone after their death, they may want to set up a trust and spell out exactly who would be in charge of that business after their death until it could be marketed or transitioned to someone in the family. So those are the typical kinds of times when a trust might be appropriate.
I see.
Okay.
Should you have a power of attorney, and if we should, why, and what do they do?
Okay, great question. Because we've been talking about the kinds of documents that are effective at your death and what happens when you're not here anymore. Powers of attorney are a little nearer in time, which is they're in effect while you're alive. They actually expire at the time of your death. So while you're alive, if there's ever a time when you're in some disability, either temporary or permanent, mental or physical, where you can't handle your own affairs and make your own decisions, that power of attorney is the gap filler that lets somebody handle things for you during your life.
I see.
So there's usually two different kinds that you would do if you were doing an estate plan. There's the medical power for medical decisions and getting your medical records and maybe making your end of life type of decisions. And then there's a general power that pretty much covers everything else except medical.
Medical power of attorney is now kind of renamed, isn't it?
Yes.
What is it called?
It's called a designation of patient advocate.
Advocate, that's
yes.
right.
Yes, that's what Michigan calls it. Some states may call it a living will. Some may call it a medical power of attorney, but in Michigan it's called a designation.
So to prepare all of this, to get your ducks in a row, who should do this?
Well,
what qualified?
Ideally, I think you should talk to an attorney. They've seen hundreds of these kinds of situations. They can A, ask the tough questions, but B, they may be able to suggest ways to handle the tough situations where there's a family member who's got a substance abuse problem. What are some ideas how we would do this? We're fearful that if our kids inherit money and then get divorced, our hard-earned dollars may go to an ex-spouse. What can we do? The seasoned professional has seen those situations before and might come up with an idea that you haven't thought of for how to handle those situations and be fair to everybody in the family and not leave a legacy of family feuds and hard feelings and siblings not talking to one another because of mom and dad's estate plan.
Now, you mentioned that if people are coming to see you, they first get a questionnaire.
Yes.
So that's the start is to contact you, get the questionnaire. What can the first visit be like? Tell me a little bit about that.
Okay.
So people know what to expect.
We ask that the questionnaire be a two-way street. So what I mean by that is I need you to jot down some information while you're at home and it's quiet and you've got your records there and you can think about the who and the what. But I also want that questionnaire to be your list of questions to me. If you've heard these myths about probate and you want the real answer, I want you to jot that down so that when we get together, I can make sure you understand the vocabulary that is associated with estate planning, that any tall tales that you've heard, we can talk about whether those are true.
Get those right out
of the way.
Okay.
And then what we do at the first meeting is what I call estate planning 101.
Okay.
So I can build your knowledge of how do estate plans come about, where do they come from, and how do I make mine reflect what's important to me and my family? Because a lot of people don't realize that the way you have your assets set up is part of your estate plan. So for example, if you have a life insurance policy and you years ago put your mom on there as the beneficiary, now you're married and you have children and you forgot to ever go back and name your wife,
Right.
I can say in your will or your trust that your wife gets everything, but that life insurance policy is going to go to the beneficiary.
Sure.
So we can't put our blinders on and just look at what I'm going to write up for you. We got to think about these other columns. Likewise with joint property. You may have named somebody on your bank account with you in case of an emergency so they could pay bills. And years later, you've lost touch with that person or they moved out of state, that type of thing. So you assume, well, that asset will go to the people I named in my will or my trust. It won't though. If that co-owner outlives you, he or she is going to get that bank account. So we go through that so that you understand where your whole estate plan comes from, and if there are any of those out-of-date documents, old beneficiaries, joint owners, we can clean all that up at the same time that we write your will or write your trust. So
How often should people update these things?
Well,
is there a formula for?
A lot of the planners, the financial planners I work with, want their clients to do an annual or every 5 years. That might work, but it's more a factor of the situation and has there been a change in the situation. So, and we have a list, and I'm happy to share it with anyone who's interested, but it's mostly big family events, okay? Your kids got married. Now you've got in-laws. You've got grandkids. You got new family members that you might want to include. Or conversely, people you named in your documents may have deceased ahead of you.
Right.
Or they moved away and they're not going to be available to be your representative or to be your trustee. Or someone got divorced. Or someone's borrowed money from you and you want to square up at the time of your death that loan be repaid. So it's usually those kinds of life events that trigger an update to an estate plan, as opposed to just everything being neat and tidy and every calendar year looking at it. It's not a bad idea, but I think it's more important to be sensitive to things that have changed in the family dynamic.
Sure. You know, this is so important to do. I mean, I stress pre-planning at the cemetery. Why it's so important
Right.
to spare your loved ones the burden. This is the same thing.
Absolutely, absolutely. And to go back to your question about, why you wouldn't want to write your own will.
Now I see it.
What if you left something that was unclear?
Sure.
Or you said things slightly differently in 2 different places of your handwritten will, and now your legacy is your family fighting over what did you mean, who was supposed to get this item, who was supposed to be in charge. I just can't imagine a family wants to think that they left behind a big mess for their
And we get the
kids.
same thing
Sure.
at the cemetery. Everyone wants something different. Everyone has a different version.
Exactly.
And, it's too hard to do at the time of need.
Right. And if you do it now in a calm moment, when there's no crisis, you can involve the entire family. You can have the discussion with everybody that you've done this. You can tell them where the documents are being kept, what's in there, why it's in there, so that there aren't hard feelings later and no one can ask you, what were you thinking? Why did you do this? You can have the conversation now when there's calm, cool heads prevailing and everybody can ask their questions.
Now, you do some seminars in the community.
Yep.
and they're free.
Yes.
People are welcome to attend. Also, they can contact you at your office. Where do people reach you to find out about your seminars or a consultation with you?
The best thing would probably be to call our office
Okay.
and get on our mailing list.
And that number?
586-783-8350.
Okay.
And we send out an email newsletter every other week.
Oh, good.
It keeps people up to date if the laws have changed, if something, we focus a lot of times on con artists and the scams that they're trying to use to target seniors. So we'll repeat things from the Attorney General's office or from AARP if we think it's pertinent to our clients. If there is an upcoming seminar, we'll notify people in the e-newsletter that that's coming up and where they can call to RSVP. So I would think that's the best way. If they want the questionnaire emailed or mailed to them, we can do that. We can give them this checklist of when it's time to update your estate plan. Any of those forms, they're free on our website, or you can call our office and we'll mail them out or email them, whatever's more convenient.
Give us that phone number one more time.
586-783-8350.
Boy, we sure learned a lot today. What valuable information. Boy, it's so important to get our ducks in a row, isn't it?
It is.
Yeah.
Yeah.
I can't thank you enough for being on our program
Well, thank
today.
you. Thank you. It's been a pleasure.
With great information.
Thank you.
Well, folks, this concludes our show for today. As usual, we'll continue to bring you topics and guests that'll help you make life's important decisions to protect your loved ones. Thank you, viewers, for tuning into this episode of Dying to Know.